Thanks for showing up this foul weather. Keep me company. National security and terrorism. National security is obviously an important value in our society, essential to protecting the freedom of speech. And sometimes there's a tension, if not a collision, between the need to protect national security and the freedom of speech. And we're still at that intersection. We may be at that intersection for some time, given the war on terror, so-called, which is somewhat perilous to the freedom of speech, in that we are tempted, in the name of national security, to restrict freedoms that we have traditionally recognized and to invoke wartime and emergency measures that wouldn't be tolerable in peacetime. For example, drone strikes against individuals in all countries, apparently, of the world, in search of getting rid of enemies who may be found in any country if we're not at war against a particular nation, including our own. And the war seems to be permanent. And so let's deal with it. A glitch from what we talked about last time, the protest speech, and the time, place, and manner analysis that we encountered in the Clark, the homelessness case, where we learned that even speech that is protected by the First Amendment can be restricted in its time, place, or manner in order to serve important government interests. And then we saw the statute that expanded the definition of restricted buildings, where you can't disturb the government operations. The statute includes within restricted buildings any place where someone who is guarded by the Secret Service may happen to appear. And a case was decided by the Supreme Court last year that involved Vice President Cheney's appearance at a mall in Colorado. And a man by the name of Howard went to see Cheney at this appearance, and he was no fan of Cheney's under George W. Bush, the Iraq War, and was overheard by Secret Service agents who were protecting Cheney at this appearance. Howard was overheard saying he was going to ask Cheney how many kids he'd killed today. And Howard stood in line to meet the vice president and did tell him that his policies in Iraq are disgusting. And he touched Cheney on the shoulder as he was leaving. The Secret Service agents arrested Howard and charged him with a state law misdemeanor of harassment. And the charge was fairly promptly dismissed, wasn't pursued by the prosecutor, and Howard then sued the Secret Service agents who had arrested him, alleging that the arrest was in retaliation for his criticism of Cheney, a punishment for having exercised his right of free speech in criticizing Vice President Cheney. The agents who were sued advanced a defense of immunity, that they were immune from suit. They were acting within the scope of their employment in protecting Cheney. That wouldn't be enough. But they said that it was not at all clear at the time this episode occurred that it was a violation of anyone's First Amendment rights to be arrested if the arrest could have been based on probable cause. Probable cause is needed in order to arrest somebody. Probable cause means a reasonable belief by a law enforcement officer that a crime has been committed and that the individual being arrested did it. So if you have your cop on the street and you observe what appears to be a robbery and you see the robber running away, you may arrest that person. You have probable cause to arrest him. Well, the Secret Service agents in the Reichley was the name of one of the agents in the Reichley case, said their defense was the Supreme Court had never established that it's a violation of First Amendment rights when you're arrested, when there exists probable cause for the arrest. And they had seen enough to satisfy the probable cause requirement. Well, the case went to the Supreme Court, and the court unanimously agreed with the agents that they were immune. The opinion was written by Justice Clarence Thomas, and the case really doesn't deal directly with the First Amendment issue, and the court left it open whether it is a violation of the First Amendment to arrest somebody in retaliation for what they just said, if independently there's probable cause for the arrest. And you can imagine a situation where somebody walking down the sidewalk yells obscenities at a police officer and then walks across the street, not in the pedestrian path, and the cop arrests the person for jaywalking. The cop would never have done that except for the fact that the person arrested has just yelled obscenities at the cop. The reason for the arrest was the exercise of First Amendment rights, but the cop had probable cause to make the arrest. Well, Justice Thomas' opinion darkly hints that the court is not going to get into the business of trying to figure out what was the real motivation of the police officer in making the arrest, so long as there was probable cause for the arrest. And as I say, that's somewhat related to the protest speech and restricted building kinds of concepts that we encountered last time. I have to say that post 9/11, there have been hardly any instances where the government tried to restrict or punish speech related to the war against terrorism. The Patriot Act and other things deal with searches and data gathering and various kinds of what are troubling to civil libertarians, restrictions on what Americans can and can't do, but pure speech seems to have been spared some of the restrictions. That's no thanks to John Yoo, whom you may be familiar with. He teaches at the law school here, and extremely well regarded by students, I'm told. Personable, entertaining lecturer, but he was in the Office of Legal Counsel in the Bush administration and was the principal author of the infamous torture memos, in which the Department of Justice said that under our Constitution and laws, the president has sweeping powers to deal with terrorism, including using unusual methods to obtain information. In one of Yu's memos, this is not a torture memo, he discusses the scope of presidential powers in dealing with the war on terror, and he spends a paragraph on the First Amendment, saying that First Amendment speech and press rights may also be subordinated to the overriding need to wage war successfully. I'm sure you can't read the fine print, but that's where we are. And then he puts in a quote from a Supreme Court decision. When a nation is at war, many things that might be said in time of peace are such a hindrance to its effort that their utterance will not be endured so long as men fight, and no court could regard them as protected by any constitutional right. That's a quote from Neer versus Minnesota, a case we'll consider in a little while, in which Chief Justice Hughes, in the Neer case, quote none other than Oliver Wendell Holmes in the Schenck case that we looked at last time, the fire in a theater, quote, case. So we have the administration, at least during the Bush administration, relying on what is essentially the discredited views of Justice Holmes in the Schenck case. During the administration of Barack Obama, what has changed with regard to the stance vis-a-vis the need to protect security against terrorism? It doesn't appear that very much has changed. In the only Supreme Court decision dealing with terrorist speech since 9/11, that's Holder versus the Humanitarian Law Project, the court upheld a federal law that restricted pure speech, in a way, talk about it in a minute, and said that the activities that were proposed by the American citizens who wanted to, quote, speak, were not protected by the First Amendment. The suit involved 2 Americans and 2 nonprofit American organizations, one of which is named to the case, the Humanitarian Law Project. And what they wanted to do was lend support to 2 organizations, a Kurdish, I forget what it's called, the Kurdish Workers' Party, the Kurdish Liberation Front, something like that, in Kurdistan. The Kurds are the largest minority in the world without a homeland. They live partly in Turkey and partly in Iraq and partly in Iran, but they don't have a nation. And the other organization that they wanted to support was a Tamil organization from Sri Lanka, but they got basically wiped out in the war in Sri Lanka, and by the time the case was decided in the Supreme Court, they weren't a factor anymore. What the Americans and the Humanitarian Law Project wanted to do with the Kurdish group was to provide them some expertise, to train them on how to use international law to peacefully resolve their disputes with the Turks principally and others, to engage in political advocacy on behalf of Kurds living in Turkey, and to teach them how to petition the United Nations for relief. Sounds worthy, but there was a federal law passed post 9/11 that made it a crime to give, quote, material support to an organization that had been designated as a terrorist organization by the Department of State. And both of these organizations, the Kurdish one and the Tamil one, had been designated terrorist organizations by the Department of State, and that was not in dispute in the case, whether they were properly designated as terrorist organizations. We have to assume that they were. And the court, in deciding the case, the opinion was written by Chief Justice Roberts, 6-3 vote, and said that even though what we're dealing with here is speech, it was expert advice or assistance within the meaning of the definition of material support for a terrorist organization. That is, if you give expert advice and assistance, that's material support for the terrorist organization under the Patriot Act. And Chief Justice Roberts interpreted the statute as applying not to independent advocacy supporting a terrorist organization, but to support that is coordinated with or under the direction of the terrorist organization. And it's somewhat reminiscent, the concept is somewhat reminiscent of what we saw in the Citizens United case, where the court says, if you act independently, you corporate political meddlers, if you act independently of the candidate's campaign, you don't coordinate with the campaign, then you have full First Amendment rights to speak politically. Whereas if you coordinate, that can be restricted by government. Case?
I think you just answered it, but I was going to ask you about independently, the word independently, but I'm assuming we just explain that this means not working with them.
Right. Right. I mean, if you decide to make a speech, write an article, write an op-ed, go on television, give an interview and say, I think the Kurdish people are being suppressed. It's basically a genocide. You know, you're going on harangue. Fine. That's not prohibited by the statute. It supports the terrorist organization, but indirectly, and it hasn't been coordinated with them, and or is not under their direction. So independent advocacy would be okay, would not be prohibited by the law, but working with the terrorist organization to provide expert assistance would be a problem. Leah?
Does the term unindicted co-conspirator, does that come out of something like a case like this?
What about
Unindicted co-conspirator.
unindicted co-conspirator? That's a sophisticated notion in criminal law.
I'm just thinking of a similar situation like the Holy Land Foundation, like a lot of people were indicted for donating money to this organization
Oh.
that's considered a terrorist.
No, donating money is without a doubt material support for the terrorist organization. Or you provide them guns or transportation or something tangible. That is without a doubt material support for the terrorist organization. Question of, did it go directly to them or did it go through some fronts or what have you? That's different. An unindicted co-conspirator, we don't need to get into that. I mean, that's a very sophisticated notion in criminal prosecutions where the prosecutor elects not to indict, not to charge somebody, even though they conspired with the other bad guys to do a crime. It's not terrorism specific at all. It's across the board, all kinds of criminal law contexts. What's somewhat troubling about the Holder, this Holder, by the way, is Eric Holder, the Attorney General of the United States, on the other side of this case, upholding the federal law. What's somewhat troubling is that Chief Justice Roberts seemed to apply strict scrutiny to this law. Says, he didn't come right out and say, we're going to do the strict scrutiny analysis, but what he did say was that this is a content-based law, and therefore we're going to look at it very carefully. And we know now that a content-based law, a restriction on speech based on its content, triggers strict scrutiny, which requires the government to prove that the restriction serves a compelling government interest and is narrowly tailored to serve that interest. And Chief Justice Roberts said that combating terrorism is without a doubt a compelling government interest. And then in looking at whether the restrictions here were narrowly tailored to serve that interest, Chief Justice Roberts said that the assistance given in this case, or that they wanted to give to the Kurdish organization, is fungible with other kinds of support. Fungible with money, for example. Fungible with wanting to provide a computer system for the organization so that their communications would work better, and so on. And the idea is if you're supporting these organizations by providing expert assistance and negotiating with the other side and telling them how to do business in the United Nations and so on, that frees up other resources in the organization to go about their terrorist way. That was the notion invoked by Chief Justice Roberts. And secondly, he said that this kind of assistance lends legitimacy to the terrorist organizations, gives them a stamp of approval. Here they've got well-regarded American lawyers and organizations backing them, that lends legitimacy and enhances their ability to harm us. And the court concludes that these factors, how fungible assistance is, and the likelihood, in the court's view, that this kind of assistance will give the organizations greater legitimacy in their struggle, amounts to narrow tailoring under the strict scrutiny test, and therefore there's no First Amendment infringement. This is one of the extremely rare cases, I can't think of another one off the top of my head, in which applying strict scrutiny did not condemn the restriction. Virtually no restrictions pass strict scrutiny, but this one did. Over a dissent by Justice Breyer, who complained that under the majority's reasoning, even filing an amicus curiae brief, a friend of the court brief, in a court would violate the law, at least if it was coordinated with the organization. Who knows what kind of coordination would be required, but if you filed a brief on their behalf and you called them up, or however you get in touch with the Kurdish organization, and said, we intend to file an amicus brief, is that okay with you, or do you have any objection to that? Is that coordination? Could be. And that's certainly troubling. Breyer thought that the statute should be interpreted to require an intention to further the terrorist activities of the organization. What the Americans and their organizations said they wanted to do was not help them do terrorist acts, but help them in their peaceable humanitarian efforts. Not their terrorist efforts. And Robert said we're not going to be able to distinguish because it's fungible. And then Breyer also said that this kind of support doesn't help the United States achieve its goal of defeating terrorism. And with regard to the legitimating rationale that Roberts had come up with, he said that's not convincing because the government does not ban membership in these organizations or independent advocacy on their behalf, both of which lend legitimacy to the organizations, neither of which is prohibited by the law, so that it doesn't make a lot of sense. Picking up on this, recently I saw that a member of the House of Representatives from Texas, Ted Poe, had demanded that Twitter freeze the accounts of Hamas and Hezbollah, both of which apparently are designated terrorist organizations on the State Department's list, saying that what Twitter was doing was providing material support to these organizations by allowing them to use the Twitter platform facilities and so on. He says, we freeze terrorist organizations' bank accounts, and we ought to freeze their Twitter accounts too. What's the problem with that? Or is there a problem with that? Isn't he right? Ruby, no? Not right? Because?
Well, because the government has a say of what can organizations say. I can't really say some material support. People say an individual member posting in support of Hezbollah. Is that lending material support to Hezbollah by speaking out on Twitter?
Well, apparently they use Twitter to